Yeah, we can do a refer for Leah Bas Esther and all the Cholim of Klal Yisrael, and for the safety of all the Jews in the world. And I wish all of you guys attending this year much bracha and success in your dreams coming true.
Amen.
Thank you. And to you.
Amen.
Gam lecha, Damon.
Yeah,
Gam lecha. Correct.
Gam lecha.
Okay, so it's continuing now with the theme of preparing cholent on modern day appliances. And there's another question. What must be done in order to properly prepare cholent for Shabbos inside the oven? And it says, it is advisable that the cholent be fully cooked before Shabbos begins. If it was not, or b'diavad, as long as the cholent is half cooked, or under extenuating circumstances a third cooked, it may be left in the oven. If the cholent is not cooked to even this extent, then the cholent may not be left inside the oven unless an oven insert is placed inside it. In the opinion of many poskim, if the cholent was removed from inside the oven on Shabbos, it may not be removed to the oven unless there is an oven insert inside. Even though in some ovens no fire is visible, still there is nothing that distinguishes the oven from its regular weekday appearance. It still looks like someone is cooking, and the chance of their adjusting the temperature is still very real. And a minority opinion maintains that if the stove knobs, etc., are covered or removed, and a piece of silver foil is placed underneath the pot, the cholent may be returned to the oven as long as it is completely cooked, still warm, and was not put down on any surface as detailed earlier. And there's just a short question, another minute. Can I say it?
Sure.
Okay, another question relating to that. What must be done in order to properly prepare cholent for Shabbos on a hot plate?
Okay.
Most poskim rule that even the cholent which is less than half cooked may be placed before Shabbos on a hot plate, even without a covering, since a hot plate has just one temperature setting that cannot be adjusted. Returning food to an uncovered hot plate, however, is debatable. Many poskim forbid doing so, while others are more lenient. In order to satisfy the views of all poskim, cooked hot food should only be returned onto a hot plate if it is covered with a thick layer of aluminium foil.
Okay.
This is why you need to find a wife so she can understand all of this and do it for you.
Exactly.
So that's our strategy.
That's our strategy going forward. Okie dokie. Guys, we're going to an easier section, in my opinion, which is much relieved. All right, so we're discussing now power of attorneys. We're on the 70th daf. So the Gemara cites a ruling with respect to establishing a power of attorney. A ruling, as will be seen, is based on the above statement by Rav Yochanan concerning a stolen article that the owner has not despaired of recovering. So the scholars of Nahadia say we don't write a power of attorney for collection of movable property. Okay. In other words, a person cannot empower someone else to act on his behalf to exact movable property that is currently being held by a third party. Okay. Now, Rav Ashi said to Amaima, what is the reason? Amaima said to him, it's because of Rav Yochanan's ruling. For Rav Yochanan said, if a thief stole some property and the owner did not yet despair of recovering it, neither the thief nor the owner can consecrate it. This one, the thief cannot consecrate it because it is not his. Because, guys, there's no despair by the original owner. And that one, the owner cannot consecrate it because it's not in his physical possession. Okay. So, what does this actually mean, and how does this relate to the power of attorney? So, I'm just going to explain to you the concept, and then it's going to make a little bit more sense to you. So, the Nahadians, which is a rabbinical school, I don't know where Nahadia is. I'm assuming it's near Babylonia. Follow their opinion that in order to litigate a case for someone else, it's not enough that the litigator be appointed as a shaliach, an agent by the plaintiff. Okay? For a defendant is not obligated to go to court with a person who is not the actual party to the suit. Even if that person is acting as an agent for the plaintiff. who is a party to the lawsuit. Okay, so again, why is he not obligated? Because there was a concept. I mean, law has amended and evolved to a certain extent, but in those days, the person being taken to court by the attorney, that's where you get the word attorney from, because he has the power of attorney to act on behalf of the plaintiff or the defendant. That's how the word attorney came. But the power of attorney was the power to act on somebody else's behalf. Now, the defendant can turn around and say, listen, you have no interest in this case. I'm prepared to come to the court if I'm sued by the original claimant involved, but not you. So the Gemara is saying that that's exactly why power of attorney can't be issued. We're going to see the ways around it and what's the case. Okay, so in order to grant the representative power of attorney, the plaintiff must transfer his ownership in the disputed property to the representative so that the representative himself be a party to this lawsuit. Okay, so in other words, almost if Shimon has a bakkie that got totaled by Reuven, and he hires Levi to be his attorney. He has to take the half-mangled bakkie and give it to Levi in order that Levi now has possession of it in order to sue Reuven for Shimon's damage. Because actually now Levi's suing Reuven. So it has to be physically in his possession. Okay? Now we've got a problem, because Rav Yochanan is saying here that it truly isn't in the possession of the plaintiff. Why? Guys, why isn't it in possession of the plaintiff? I can't hear you, Kev.
The thief has it.
Exactly. The person that you entrusted to look after it, or the person that stole it from you, etc., has possession. So since you don't have possession, you don't have the possession in order to give it to the representative on your behalf in order to have an interest in the case. That's the bottom line. So it's a bit of a catch-22. We're going to see a way around it now. So exactly as Kevin said, well done, Kev. So rather, in order to grant his representative power of attorney, he has to be a party to the lawsuit. And Rav Yochanan said, by inference, transfer of ownership, in other words, movables that are not in the possession of the owner, cannot grant power of attorney over those movables either, because it's in the hand of another party who you're disputing that you should get it back. I mean, I think a case legally in point is that you take a car to a mechanic, and the mechanic gives you some ridiculous bill at which he never got a proper authority to the quote, and he's saying he's holding your car captive until you pay the bill. Now, you don't have the car in your possession, so you can't transfer that to the legal representative wishing to act on your behalf as power of attorney. So since it's not in his possession, he doesn't have an interest in the case. And since the panel beater or the mechanic might say, well, who are you? I don't care if you were represented. You had the representative rights or the power of attorney by the original owner of the vehicle. If he's got an issue with me, he must take me to court. Exactly as Kevin said. Well done, Kev. So, accordingly, if you did grant power of attorney over movables that you deposited with a third party, the power of attorney is invalid, guys. And in fact, the custodian did hand over the movables to the representative, and they were lost before being restored to the depositor. Why? Because the custodian remains responsible for them and can be sued again by the plaintiff. So we've got to actually distinguish a little bit at this point. Well, not at this point. We're going to deal with where there was an agent appointed first, like a custodian, and then he claims it was stolen from him. Now, originally, he was going to look after it on behalf of the owner. So in that case, you can technically write a power of attorney, because it's in possession of the owner. It's the custodian that was selected by the owner that has a problem. Does that make sense? In order to safekeep it. But if it's a normal thief or a third party that had no permission to look after it for you, other than to do repairs, there's a heck of a problem, because as the owner, you don't have permission to grant another party to act on your behalf, because they don't have any vested interest, and that in order to have vested interest, they need possession of that issue, of that particular movable asset. However, guys, you must know that it's different with regards to land. So if there's a land dispute, you can have a power of attorney, because even if there's a property deed or whatever the case may be, land can't be stolen. I mean, it can be legally, contractually disputed, but it ain't going anywhere. So there you can have a power of attorney and it's valid, okay? So if you look at a simple reading of Rashi, it suggests that the reason we don't write a power of attorney of immovables is because the defendant will remain liable for the movables even after he hands them over to the plaintiff's representative. In other words, according to Rashi, he's saying, look, the arm as the defendant gave it to this person claiming to represent the original owner, and then the original owner comes to me in court and says, well, where is it? I said, I gave it to your representative. He says to me, what representative? So we don't necessarily trust the power of an attorney unless, I suppose, it's court appointed and they've got witnesses, etc. So that's also the issue. But Bnei Yeshua has issues with it, because he asks why it didn't suffice for Rashi to explain, basically, that the reason we don't write a power of attorney for movables is that the defendant can refuse to go to court with anybody other than the plaintiff. And since you cannot transfer ownership over movables that are not in the possession of the plaintiff, you cannot render his agent a plaintiff through power of attorney. So Bnei Yeshua answers that the Nahadian statement, in other words, that we do not write a power of attorney for movable property, actually suggests that aside from being ineffective, it's also forbidden to write a power of attorney for movables. So Rashi therefore has to add that since the power of attorney is ineffective and the defendant would remain liable for the movables if he gave them willingly to the agent, because it's not a legal transaction since the agent doesn't have any vested interest, it's forbidden even to write such a power of an attorney so as not to deceive an unwitting defendant. Okay. Now there's a discussion on Tosfot and Ramban, Nachmanides, in Milchamos, and they explain that the Nahadian's ruling that a power of attorney cannot be granted over movables, guys, only pertains to movables that were stolen or monies that were lent. Okay, that's the difference. So Rav Yochanan rules that you can't transfer ownership of movables that are in the possession of a thief or somebody that you lend money to in terms that out that they kept the money, they're thieved, but you can transfer ownership that you deposited with a custodian. It's different to cash, because such movables are considered to be in possession of their owner. So if you look at the 62nd daf, we've got to distinguish here the difference between cash and movables. So if I say to a custodian, I'm going to Australia, look after it for me, I've got a document that he signs that he's looking after my animal on my behalf. And therefore, if anything happens to it, it's technically my animal that he was meant to look after. So in that case, the power of attorney suffices. It's different if I lend somebody cash, because he could turn around and say, well, you gave me the cash. And if it's in a document, well, there's no cash as such. So then the power of attorney is a problem if you lend money. And it's also a problem for a thief as opposed to a movable. Okay? So basically, you can grant power of attorney over them as well. But Rashi, it's evident that the Nahadian's rule applies even to movables deposited with the custodian. Okay? Because he's basically saying, well, if it's not in the possession of the owner anymore, you can't use a power of attorney with an agent, because you can only have a power of attorney when the person acting as an agent has a vested interest. If there's nothing to give him as a vested interest in terms of the animal itself to as an asset, he can't act on your behalf. Okay, so I just want to move on. You guys get it? There is an alternative answer, and I think you should look at this. There are those who state the following version. The Nahadians say, we do not write a power of attorney for collection of movable property that the defendant has denied. Okay? And when we say is denied, it's basically where the depositor has already sued the custodian in court to return the deposit, but the defendant denied the claim. He's saying, look, I gave you money to look after from me and my possessions. He said, what are you talking about? Maybe it was two friends that had the arrangement and there was nothing in written contract. So when that's the case, then there's a problem, because according to this version, the only reason we don't write a power of attorney is that the defendant denied the claim, because it has the appearance of falsehood. What do we mean, the appearance of falsehood? The power of attorney document states that the plaintiff is basically transferring to the agent his ownership of the movables that are in possession of the defendant. But since the defendant denies that the property of the plaintiff he even received at any point, the plaintiff appears to be transferring to the agent property that we don't even know is his. So the witness who signs such a document gives the appearance of signing a falsehood, meaning you can't base a case on that because we don't even know if it's legit. Okay? So, but where he did not deny the claim, meaning there are two friends that entered into an agreement. Let's just take the example of two friends out. Let's just say there's not a denial. Let's just say I took my car to a mechanic. He's charging a ridiculous fee and I want my car back and he wants to be paid. He's not denying he kept my car then, but he says he wants to be paid first. So in that case, we do write a power of attorney for collection of movables. Okay? Because according to this current version of the Nahadian statement, the defendant didn't deny the plaintiff's claim in court. And there's no appearance of falsehood. So you can write a power of attorney for the collection of movables. Okay? So even though the movables are not in his possession and he cannot legally transfer his ownership to the agent who's acting as power of attorney, he can nevertheless grant power of attorney to his agent. So Ramban Nachmanides in Milchamos explains the mechanics of it as follows, right? The fact that you can't effect a legal kinyan to transfer movables that are not in his possession only serves, guys, to render his conveyance of the movables to his agent as non-binding and thus retractable up until the point that the agent takes physical possession of the movables. So what it's basically saying is that you can't, because it's not in your possession, you can't give the agent a power of attorney based on the fact that he's got your possession in his trust account because it's being held by the mechanic. So you have to write the contract as non-binding and retractable in case the case isn't won. However, basically, if the agent sues the defendant and is granted the movables by the court, the agent does acquire the movables when he takes possession of them, right? So that makes all the difference in the world, right? Because accordingly, the owner's transfer of the movables to the agent grants the agent an ownership interest in the case. Because we're saying, well, then how does this work with Rav Yochanan? Basically, the agent, the shaliach granted the power of attorney, has to have some financial interest in the case, because if that's not the case, the person being sued is going to say, well, I want nothing to do with you. If the original person has an argument with me, he must take me to court. And we find that even if the agent that's acting with power of attorney doesn't have an interest, he can't represent the plaintiff. So what we're saying is here, he does have an interest. Why? Because if he wins the case, then the asset gets transferred to his trust account from the defendant, if the defendant loses the case. You get what I'm saying? So therefore now he has a financial vested interest and he can be granted a power of attorney. So it basically, he says, go sue the defendant in court, win the case, and procure the proceeds for yourself. So he gives him an ownership interest in the case, which divests the defendant of his right to refuse to go to court with anything other than the actual plaintiff. So accordingly, what it's saying is the defendant can't turn around and says it has nothing to do with you, because the agent acting with power of attorney says it does, because I stand to gain as a result of going to court with you. I am an interested party. I'm a vested party. I stand to gain financially. The only issue I have with this, as explained so far, at which we will tweak it a bit, is the fact that why go through this if the shaliach, the agent who's granted power of attorney, gets to keep the whole asset? Then why even bother suing? I mean, you're not going to get back anything anyway. What difference does it make who it goes to? So far, that was my irritation. And then as we learn further, it's going to become clear. What were you going to say, Gav?
No, so I was thinking the same thing as you, and I was thinking that they presumably he's only getting a portion of it, not the entire thing. That's what I was thinking.
Excellent. I was thinking exactly the same thing, and that's what we're coming to learn. So at first it says, exactly as we thought, Gavin, the Gemara cites another ruling by the Nahadians with respect to granting power of attorney. And the Nahadians say a power of attorney in which it's not written, in other words, go sue the defendant in court, win the case, and procure the proceeds for yourself, has no substance. What is the reason? For the defendant may say to the agent who bears a power of attorney lacking this clause, you are not my litigant. So exactly as Gavin and I said up until this point, is that even though that statement affects a case where the defendant can't say, I'm not interested in appearing in court with you, the agent who has power of attorney, he cannot say that, as the Gemara said, when the original owner says to him, if you win the case, you can keep all the proceeds. So Gavin and I thought quite realistically, as I'm sure Kevin and Arthur did, that he must only be able to keep a portion, otherwise why go through it? So the Gemara modifies this ruling exactly for this issue, because a buyer said, and if it is written, procure for yourself a half, a third, or a quarter of the proceeds, exactly as Gavin was saying. In other words, the attorney, or the person granted power of attorney, who we now shorten to the word attorney, gets half the money, a third of the money, or a quarter of the money. He is empowered to litigate for the collection of his half, or third or quarter of the claim. He may litigate for the collection in entirety. So what the Gemara learns from there is, although the plaintiff did not transfer to the agent all his rights of ownership, because he technically doesn't own it, the defendant has it in his possession, the latter may nevertheless sue the defendant for the entire claim. Why? Because as long as, Gavin, he's got an ownership interest, it doesn't have to be for the whole amount, the defendant cannot refuse to litigate with him in court and under the claim that he has got no business interfering in this case. So he's now empowered as the legal agent of the plaintiff to litigate on the plaintiff's behalf as well. Doesn't mean he has to keep all of it, can keep a small portion. So the Gemara discusses the ramification of the clause, goes to the defendant in court, win the case and procure the proceeds for yourself, meaning, you get to keep a certain amount. Rav Amimar said, if the agent wins the case and seizes the proceeds for himself, we do not take them away from him. So this is a little bit difficult to understand. Why? Because since the plaintiff transferred his ownership of the movables to the agent, if the agent wishes to seize the entire proceeds and keep him for himself, he's entitled to keep him and he need not give them first to the plaintiff. So that for me is already a bit of a problem. And Rav Ashi also has a problem with it, because his response is, since he writes to the agent, I accept upon myself all expenses incurred on account of the litigation, it's evident that he appointed him only as the agent, which means that Rav Ashi doesn't agree with Rabbi Maimar and says he has to write that specific statement there. And the reason being is that the original owner has to accept the outcome of the litigation. And he's saying to the attorney, you can conduct the court case on my behalf, whether it's to my benefit, like we win the case, or to my detriment, that I still owe you legal fees. That's what he's saying to him. So now this is the first time there's an issue that's brought up of maybe instead of just winning a portion of the proceeds, like suing on commission, you actually get paid for your time. That's the first point that seems to be bringing this, So in other words, if he actually meant to give away all of his interest in the movable, why would he pay for the costs of procuring them? So that's the statement. In other words, if he's paying for, there's either two arrangements, Rav Ashi is saying. Either he gets a portion of the winnings, like commission, or you're paying for his time, but it cannot be both. It cannot be both. He can't have it both ways. Does that make sense? So, and also, this thing with Rav Ashi is saying that it's evident from the language used in the power of attorney document that he's only meant to appoint him as the shaliach, the agent. It's obvious that when he wrote, go sue and procure the proceeds for yourself, he meant to set up a trust account, guys. It wasn't to keep the proceeds permanently. So one other arrangement we learn is it could be a loan, by the way. So say, for example, somebody knows the law well, but he's got a cocaine habit, okay? So he blew the money, or let's not use that, because I wouldn't give any attorney with a cocaine habit my money to collect, because it would go out of the trust account, and there goes the trust. So let's just say he had an ex-wife, and that ex-wife had a better attorney than the one you're hiring, and left him broken, blind, half blinded, without assets, or whatever is, he needed the money, whatever. He's saying, look, I need a bit of money to loan. I'm prepared to spend all that time researching the case and working on your behalf, but I need to borrow the money for a certain period when I collect it, and then pay you back. In other words, he's then not acquiring a portion, nor is he charging time fees. He's acquiring the ability to have a loan in order to defend the case successfully. That's also an option, although I would run away from that attorney in 2 minutes, by the way, because you won't see it. Rather, Rav Ashi says he meant only to grant the agent the right to borrow and use the proceeds until he returned from court, whereupon he is to pay them back. And although the plaintiff did not then transfer complete ownership of the proceeds to the agent, that's the key. He didn't say you can keep all of it. The agent's right to use the proceeds until he returns to the plaintiff is sufficient to be considered an ownership interest in the case. So what he's saying is, listen, if the agent working with the power of attorney on behalf of the original owner is going to get some financial interest, even if it's an interest-free loan when he wins the case, that's enough of an interest to work on the original owner's behalf and take the defendant to court. Okay? So then we've learned 3 different options. You earn by commission as an attorney. You earn, you get to keep a quarter, half, a third of whatever the proceeds are, whatever the arrangement is. The other one is that you get to earn on your time. Since he writes to the agent, I accept upon myself all expenses incurred in amount of the litigation, you realize when you talk about expenses, it's not a portion of the litigation. It's legal fees for time and expertise spent. So, another version of Rav Ashi's response to Amimar, and there's an opinion that states the following version. Since he writes to the agent, I accept upon myself all expenses incurred on amount of the litigation, it's evident that he made him only a partner, not the owner of the entire amount. So that's quite clearly, guys, saying that even if he writes that statement, it's clear that he doesn't get all of it. But you've got to be very specific in your wording with the attorney as to, I would advise, whether it's commission or time spent or whatever the case may be. You don't want to have two legal cases on your back. Okay? So the Gemara explains what's the practical difference between the two versions. With regards to seizing half the proceeds, that's according to the second version, the agent is a partner, is empowered to seize and keep half the proceeds. But according to the first version, that he's only an agent, he cannot keep any of the proceeds. Okay? So according to that first version that we learned, the whole reason he's not granted power of attorney is he has no financial interest. So the defendant can say, well, it has nothing to do with you. Go, the original guy must take it up with me. So that proves that there was no financial interest in the first case. In the second case, there is. And what do we mean he makes him a partner? He gets a partnership share of commission, or according to the other version, he certainly charges expenses on account of the litigation, whether the case goes in his favor or not. And what's the law? Do we go according to the first version of the Nahadians or the second version? Well, we go according to the second version because he appoints him only as an agent. And what does that mean? It means the agent cannot seize and keep any of the proceeds for himself. So what has to happen then, I'm assuming, is that either he has to return most of the proceeds according to the agreed upon sum, except what he was going to earn to commission to the original owner, so he has a financial interest, or alternatively, he charges legal expenses for time and expertise, or the third possible alternative is he has to use a trust account, just like when you buy and sell a house, to transfer the entire proceeds to the original owner, at which the original owner will pay him from there. But I'm assuming the most practical is to just pay him the balance minus the commission or minus legal fees. That's what I'm assuming, guys. All right, we've completed that. Next time we're going to deal with a new Mishnah. I thought this was quite productive. It went rather quickly.
Damon?
Yeah.
This attorney or agent, how was he originally appointed?
So he was appointed by legal contract, but what the Gemara is saying is that there definitely has to be a vested interest for the person that's doing the litigation on behalf of the owner of the goods. Because the difficulty is basically that this contradicts Rav Yochanan, because Rav Yochanan says the thief doesn't own it because the original owner didn't despair. The original owner basically has no possession or control over it, and therefore that's why the second thief doesn't pay him double, the original owner. So therefore, how do you make sure that the agent that you grant a power of attorney is actually going to be able to litigate the case when the defendant would say, it's got nothing to do with you, let him take me to court? Because he can't transfer the original possession to the attorney and say, listen, you get to keep some of the proceeds if you win, because the cars won't be released from the mechanic because the mechanic's waiting for money for repairs. He didn't deny the claim. He just said, I'm not giving you a car until you pay for the repairs. And the owner of the car is saying, but you never gave me a proper quote. So what it's stating here is that, according to the second explanation, is that either there has to be some sort of a commission where they're partners in some sort of profitability, so that if he goes to the defendant, he says, I'm representing such and such, and the guy says, it's none of your business. He said, it actually is my business, because I get to keep, when I get the car, a certain value of the car, or he's paying me for my time. So yes, I've been appointed and I have a financial interest. That's what it's saying, because that's the only way we deal with Rav Yochanan's contradiction.